You're listening to the Valley Current.
We want you to do a funeral invitation, which has nothing to do with marriage and nothing to do with man and woman. Our dad or father-in-law died, and we're married, and we want a nice website for the funeral. I think they could do that test. And if she says, look, I just don't do funeral stuff for people that are, so even though your dad was heterosexual.
Right. So in other words, it wouldn't be an invitation to a gay wedding, but there would be content about how this arose, the circumstances that would indicate that there was already a gay marriage. In other words, Peter and Paul are sad to announce that Paul's father has died, and we wish to invite you to. So could they do that?
Right. Like Paul.
Yeah. And would she then refuse? And if she did, could she then refuse?
Right.
And I don't know if she would, but could she?
She probably could. She probably couldn't, because the view would be you're not tying it to the message associated with one man, one woman getting married. You're tying it to the relationship of the father-in-law to the couple who's now married, that you're somehow protesting. This has nothing to do with your religious beliefs being in conflict. You're essentially saying you don't want to help gay couples in any context. And I think Lorie Smith said, no, she's willing to help gay couples sell cars and buy have websites for houses and all sorts of stuff that suggests, hey, she's really open for business. This is all about the situation involving marriage. That's the way Lorie Smith's lawyer framed it. We actually saw her in that video, and we hear her on the audio. So obviously, Colorado has an administrative operation that can do that kind of policing if they want to do it. And if this case doesn't lay out some broad framework that suggests that Lorie Smith can basically disassociate herself from any symbolism of support for a married, which is constitutionally allowed, marriage. Well, now it's even allowed from a statutory point of view as well, because today is the day that they pass the federal statute on gay marriage. So even if the constitutional right to gay marriage falls, which doesn't look like it's that relevant anymore, there's a backup federal statute now that legalizes it as a matter of federal law throughout all 50 states. So in many ways, this area of law is developing in a way that now raises how states decide to do the policing of what might be called a discrimination against a suspect class, or a class of gay men and gay women, and gay and men and lesbian women, and I guess transgenders and everything else that fits within the LGBTQ category. But at this point, so I think they're going to fashion something that is probably narrower rather than broader. And I think to some degree, it's going to be less than what ADF, the Alliance for Freedom, wants to get. And it's going to be designed to say, we're going to have to expect that there's going to be other cases, and we're going to develop a case-by-case approach. I'm not sure they're going to take another case on stipulated facts, but maybe they will. I think the 10th Circuit kind of went out on a limb with this business of every artist produces unique products, and therefore every artist can be regulated because these are unique products. And if we don't regulate them, it's a free-for-all. And I don't think the Supremes are going to allow it. I really don't. Right.
I think so I think the chances of a broader ruling increased with the broadness of the 10th Circuit holding that's going to be reversed.
So your view is it could result in a reactionary ruling from the U.S. Supreme Court that's designed to say there are very broad First Amendment rights associated with unique.
We don't have, yes, we don't have to stake out the farthest possible, whether the florist is covered, whether the caterer is covered. But if there is cognizable artistic expression, plaintiff wins, period.
Even if you can segregate that expression in some fashion.
Yeah, I mean, mere subterfuge is not going to fly. I mean, the subterfuge on the other side, we're not taxing Jews, we're just taxing mezuzahs. That's a subterfuge. It's not going to fly. Okay, a plaintiff who puts out generic products, but puts a little heart at the end, that's their artistic expression. No, that's not enough. But so there will be a limit, but we don't have to define where the limit is, and it's going to be pretty far out.
And at the same time, I think you note, or we have talked about, this looks like a problem that is so sort of questionable as a problem, because even Colorado said something like, look, she should just define the scope of her services, like define that she wants to do Christian weddings. That's the business she's in. She really just wants to do Christian weddings. And she should say, my services will always include a footer that says specifically that this website
That's the next topic I wanted to bring up. Let's even assume that plaintiff loses. Can she then obviate the problem by putting in artist designer note? I do this because I love to further the cause of marriage between one man and one woman, all caps in red, okay, at the bottom of the page. And in that way, she's willing to sell to a gay couple, but no gay couple is going to buy it. So the problem will never arise.
Right.
And you said, yes, but the gay couple can then just blank out the designer's note.
Yeah, and
okay?
She's not going to be able.
Can she prevent that by putting the contract between buyer and seller in the form of a license that restricts the ability of the buyer to do that?
She could try to do that. Whether she could actually enforce that as a matter of forcing the gay couple to provide that speech, which they don't want to provide in their website, where she's not in control of the website anymore because she's released it and they have it hosted at some other place. I don't think she does hosting. I think she develops the site and then it gets hosted by another company. And fundamentally, I mean, these are short-lived things, right? They typically issue for maybe 6 months, save the date kind of approach, and then they disappear. Maybe they get archived, but they're basically not forever. And so you really wouldn't be able to get an injunction on her behalf saying they publish without my attribution, they publish without this, they publish without that. I think a federal court, state court, any court would look at it as kind of trivial. Like, really, what's your damage from that? Well, I'm somehow.
Well, I'm not so sure. I mean, she wants to control the
attribution,
the reputation and high quality of her services. She doesn't want the buyers to monkey with it. But you don't think that would fly? I mean, forget the gay business. A licensor cannot create a license restricting the ability of a licensee to alter the product. Is that right or wrong?
No, they can, and they can lock the product, and they could say, I'm the only one that can make changes, and they can more or less make it impossible technologically to make changes, or near impossible. But the reality is, if the changes were made somehow, if in fact the footnote could get removed through some hacking or otherwise, would any court give some type of injunctive relief to the, in this case, 303 Creative, saying, I issued a website, it needed my attribution, it needed my statement, I have a contract that says I'm entitled to it. I just noticed that they obliterated the footnote that I put in. I think most judges.
How about $100,000 in liquidated damages?
Well, it's got to be reasonable, right? Liquidated damages requires that you couldn't estimate the actual damages, but that your estimate isn't punitive.
No, because there aren't any.
Right, right. I mean, you could try to do a lot of things, but obviously the bigger point is most people that see there's that requirement that they think is offensive, they're probably going to shy away using her. So she is effectively defining the scope of the services she provides as services for Christian weddings. And that's what she does. And that's what she promotes. And the state of Colorado answered that question for either Gorsuch or Kavanaugh or one of the conservative justices, that yes, that Colorado law does not prevent the scope of services being targeted at a particular segment of the market, right? It's like lawyers who just do, high stakes bankruptcies. They won't take consumer bankruptcies. They're open for business as I don't think it's really a public accommodation, but conceptually they're open, but they define the scope of their services as targeted at a particular type of client and a particular type of case. And presumably she could do the same, right? She could say that I want to do Christian weddings, which is one man, one woman, period, full stop. And that's what I'm open for business for. I don't know why it's called 303 Creative. I assume maybe she
could live at 303 Main Street. I mean, who knows?
Exactly. But it probably was a generated case. I doubt that Lorie Smith went to a lawyer. I doubt that the backstory is really that Lorie Smith was really worried about being prosecuted. Maybe there is some truth to that. It's very clearly a setup case being created by a private interest group called the Alliance for Defense of Freedom that is bringing these cases to.
Well, remember that the ADF represented Jack Phillips and the cake case, and the cake case is famous.
Right.
It had no result in terms of legal precedent, but everybody knows about it. So, and certainly all the Christian activists know about it, and so have heard of the Alliance in Defense of Freedom. Right. So if Lorie had an issue or thought she had an issue and was talking to a friend and say, gee, I hope the Human Rights Commission doesn't land on me, the friend would say, you just go to Christy Wagner and she'll do your business for you.
Right.
It's gratis.
Right. And you could say she's gotten some degree of publicity. Maybe her business has actually increased in Colorado or even nationally for that matter. But you have to ask yourself if she's delivering services nationally, she's got to worry about the laws in California. If she's doing business with clients in California, the laws in Massachusetts.
She doesn't have to worry. The ADF will pick up the nickel if California gets on her case.
Well,
they'd be happy to.
Yeah, I mean, there were 20 states that did submit amicus briefs in support of the state's position. So Colorado is not alone here in having these public accommodation laws, which we can think of historically as, buses and trains and restaurants and all these places which discriminated against Blacks historically from, whatever period of time, from the time of the Civil War, I suppose, going forward to the 1950s and 1960s, and even maybe to some degree beyond. And those laws are designed to prevent status-based discrimination and have been broadened to more than just the race question, as you noted.
Let's talk about that for a couple of minutes.
Mm-hmm.
The cake case in this case is that there are rare cases. In other words, how many other cake bakers have refused to make cakes for gays, and so how many people were affected by the ruling in Magnificent Cakes or Masterpiece Cakes? None. These cases happen once every 10 years, and if they do happen, there are alternatives. You can go to another baker. Yet everybody's really up in arms. If you read the Washington Post, you sent me an article. If you read the comments to that article in the Washington Post, thousands of people are afraid that the Supreme Court will hold for the plaintiffs, and then horrible things will happen. Blacks won't be able to eat at Woolworths anymore, and people will be thrown out of buses again, and all this stuff. How far do you believe that there will be detrimental consequences, spilling beyond the once in a decade, baker and the gay couple with the wedding cake?
Yeah, I don't see the slippery slope consequences in real life, because I do think that we've evolved as a society throughout most of the 50 states, if not all of them. I suppose there can be pockets of states where we haven't so evolved. But in general, because I suppose what you're hinting at is this is another fracture of the red-blue division in the United States. And they're
I actually do not know, because I have no experience of what the Oklahoma legislature is likely to do, or what people in Oklahoma are likely to do. And it could be that there will be consequences.
Well, what consequences will exist is the writing of some type of exemption, because apparently Colorado law has some sort of political exemption written into it that says you're exempt from this otherwise neutral accommodation law, the public accommodation law, if it involves something that's against your politics. I haven't read the exemption, but apparently there's some exemption. There was a hint by Wagner for Lorie Smith for 303 Creative that, they need to write an exemption for First Amendment activities. And that's what would make the statute constitutional. So it's a little bit like we're in this area where there may have to be lots and lots of drafting and redrafting of the statute, that sort of thing. And
that's why I think the 10th Circuit and the stipulated facts that grew out of the 10th Circuit holding can be significant, because that gives an extremely broad view of what First Amendment, the area protected by the First Amendment, has gotten a lot broader, I think, as a result of that.
Yeah. And you may be right. I mean, it's hard to read, because it seems as though there's certainly the liberal justices who think this is just the product. It's off the shelf. There's no issue here. This is an easy case to basically agree with the 10th Circuit. I would put in that category Biden's appointee, which is Jackson, Sotomayor, Kagan, and that's it, right? 3, right? It's just those 3, right?
I would be surprised if Roberts held for the defendant. Would you?
Right. I mean, Roberts has been moving towards more of a neutral stance, probably because of some of the extremism that I'm sure he sees or feels from.
The real case of extremism was the independent legislature case, which, thank God, we're not going to deal with today, but we can in a little while.
Right.
And if that went through, I would be floored.
Yeah.
Because I think Roberts and the 3 liberal justices are pure write-offs, and that means that the proponent of the independent legislature theory have to bowl a perfect score with the other 5. And I'm not at all sure that will happen, though I guess it's conceivable.
Right. I mean, they're counting on it. I mean, that's kind of a separate case to deal separately, because, what I want to point to as we wrap up is the First Amendment jurisprudence is changing, or is getting clarified, or is getting amplified. I'm not sure how to put this in a way that sounds reasonable, but these cases that are being taken seem to me to be intentionally designed towards getting some additional vigor into the Bill of Rights in a way that is sort of contrary to what most people from our era, when we studied in law school in the 1970s, was, well, yeah, the Bill of Rights is important because we want to protect individuals from the federal government. And now it's more like, no, we want to protect, these religious zealots who want to be able to do what they want to do, regardless of what the effect is on others. And I don't say that in a discriminatory way, but it's not the same as it was 40 or 50 years ago in thinking about the bill.
I would put it a little differently. I would say there's a liberty interest. In other words, Lorie Smith wants to do her business the way she wants to do her business. And Jack Phillips wants to bake cakes the way he wants to bake them. Now just leave me alone. So that's the liberty interest. There's an equality interest that liberty interest aside, it's circumscribed by treating other people equally.
Right.
And those two historically pull in opposite directions.
Right.
Okay. So in the economic sphere, if everybody is free to make as much money as they want in any way they want, that will produce more unequal class structures or economic outcomes as time goes by. If you tax or otherwise circumscribe the ability of people to make money any way they want, that will lean in favor of equality. So liberty and equality pull opposite ways, broadly speaking.
Right.
And what these cases say to me is that the equality forces are losing cases and the liberty forces are winning them under the current makeup of the Supreme Court.
Right. And then you have to add a third leg to that stool, which is the administrative state that enforces the regulatory interest. That administrative state, like the Colorado Human Rights Commission, has grown larger and larger as a bureaucracy and is engaging in more and more things.
Yeah.
Like Gorsuch said, re-education. Didn't Jack Smith have to get re-educated? And the lawyer for Colorado was like, no, he just had to be, he just had to learn more about Colorado law. And
yes, wasn't that something?
Yeah, I mean, it was like.
And then Gorsuch says, I call that re-education.
Right.
I mean, so you can kiss that vote goodbye, yes?
Right. I mean, it was like a statement that, look, we don't want this huge administrative state that essentially takes away from the liberty of citizens because of this, alleged equality interest that, may or may not really be an equality interest. It's like the view is the administrative state is stifling, and it harkens to this view of China, which is, well, we have to re-educate you. That's what's going to happen here. We have to put you into a re-educational program. Like, I think Gorsuch was really trying to underscore in many ways his view that the administrative state ultimately becomes.
That is not a false view.
Right.
I mean, the next case that you and I deal with will be the affirmative action case. And let me say that for people who've been away from the academy, since George Floyd was killed basically 2 years ago, there's been this total revolution in how universities deal with these matters. And there's a new movement called DEI, Diversity, Equity, and Inclusion. Mm-hmm. And all hires of staff and faculty have to show good credentials that they have supported diversity, equality, equity, and inclusion. And if they don't get the job. Or if they already have a job and they do things in derogation of diversity, then they have to be retrained to do it. In the corporate field, large corporations are requiring the employees to do diversity, equity, and inclusiveness in courses. So these are not weird hypotheticals at all.
Right. And I want to close with this idea about First Amendment jurisprudence, because I think you did a good summary on the liberty interest and how that's reflected in the Bill of Rights versus this equality interest, which also is in the Bill of Rights and the 14th Amendment and so on. But
well, now it is, I mean, due to the 14th Amendment, but yeah.
Right. But
being incorporated, yeah.
But in general, we're seeing these cases, and I've commented about a couple of them. One of them is this Jack Daniels First Amendment parody trade dress case that the court recently accepted review on, where again, a lot of people are scratching their heads saying, is the court going to reaffirm a broad First Amendment principle to arguably disparage and otherwise dilute the protection of the famous Jack Daniels label and the famous look of the Jack Daniels bottle by a toy for a dog, which is put out by a completely separate company that essentially wants to make a parody out of a product. And so they took review of that case. People were kind of surprised because they thought to themselves, well, what are they doing? Are they going to go in a direction of supporting this idea that this case is really something that the First Amendment should actually address? So that's a separate topic for a separate time, but I can tell you that case was a surprise for people. And again, it's coming under the heading of First Amendment. And so, this dog toy is sort of something that's gotten some news because it's been in litigation for a while. I'm not sure you know of it, but
no,
I should show you a copy of it just so you can see it on the screen because it is kind of hilarious.
All right, let me get back to that.
And I doubt that there's been any actual confusion on the part of any person that buys this toy. I think it's not like an affiliation. There's sort of the squeaky dog toy that is leveraging off of the label. And so they took that case. And then recently there was a copyright case they heard argument on involving this Andy Warhol derivation of a photograph that the copyright was owned by the plaintiff, and the First Amendment fair use type argument was made. And people were kind of surprised that, hey, this looks like a case again where the First Amendment jurisprudence is being pushed to the limit. So I don't know if we're going to see more of it. It seems as though there's a lot of it all happening at once. Like if you look at what's going on, it's one of those things where you look back and you say, wow, this is quite an interesting development in the law. Now, I don't know if that's intentional or if that's just the way sort of cases come up and just happens to be the way right now. I don't know if you know about this Warhol case as well, where there's sort of a colorized version of a black and white photo. But in general, these cases are making their way to the U.S. Supreme Court at a time when people are scratching their heads saying, isn't the court sort of busy doing really important things? And I think it's your point about, did this case really matter? Did this case involving, wedding invitations really matter in the big scheme of things, given much more?
Only implicatively. Again, right? Every other website designer will be happy to do wedding invitations. Buyers will not be at a loss.
Right.
Okay. And so this case will come up, once in a decade, just like Jack Phillips and his cakes will come up once in a decade. The question is whether there are implications for, and we'll see.
Right. It's almost like,
in and of themselves, they don't mean a heck of a lot.
Right. It's almost like saying ADF is targeting a way to build some precedent for the much bigger set of cases they plan to bring. So this is just one chink in the armor that they're trying to get a foothold on to support kind of the next set of cases. There's like a big business plan for the way in which this more conservative court is used in future litigation to develop this liberty interest, I suppose, over the regulatory interest and even over the equality interest.
Well, the regulatory interest is there to vindicate the equality interest, the way human rights laws are written. So it's one against the other two, to my mind.
Right. I agree. So, Bob, thank you for spending.
Yeah, that was good.
I appreciate it. You're so on top of this stuff. It's really good to get your views, and thank you for putting all the time in and listening to that fairly lengthy argument. I'm sure if the public were to listen to stuff, they'd be so confused. It does take a trained ear And it's,
Well, it's interesting that none of the comments, and it was not just the Washington Post, but Slate and Salon and all this, nobody seems to have a clue about what went on.
right.
It's sad, but true.
Right. There's the, the thing about the Supreme Court, this Supreme Court, like, I think of it as it's less intellectual. It's more like, I don't know the right way to put it, because I think it's become perhaps, maybe it's just the style of the cases that are being presented, but it's more pedestrian. Like, it's not high level legal principles anymore, as far as when my ear listens to it.
No, the Supreme Court doesn't put it in terms of liberty versus equality. What will we do?
Right.
It has, I mean, that's my gloss. It's not their gloss at all.
Right. And I don't understand that, because you would think, as the highest court in the land, they would be taking cues from the previous, much more scholarly courts, or scholarly versions of the Supreme Court. I mean, we don't have a Justice Holmes on the U.S. Supreme Court at this point. I mean, we don't have these unbelievable scholars on the Supreme Court. You could argue that's just the function of the politics of selecting a justice. And I'm not trying to be negative. These are all very smart people, but in my way of thinking, they also are dealing with stuff at a level that's not as symbolic of a set of, or it's not at a higher level of abstraction, I suppose might be the way to put it, from the sound of the questions, right? It's not at that higher level of jurisprudence. At least that I don't get in that 2.5 hours. There might have been maybe 15 minutes of
there was one point where they touched on it. There's this Professor Volokh, Volokh,
right.
Yeah, and he submitted an amicus brief that Kavanaugh paraphrased.
Right, I know him personally. He's at UCLA.
Do you?
Mm-hmm. Yeah, yeah.
And what Volokh said was the cake case should be ruled for the state because there's no artistic expression in putting yeast and sugar together. Okay, but when it comes to a case with literal content of actual sitting down like Lorie Smith and writing stuff, that goes the other way.
Right.
And that's as far as it went. I mean, right. That's all the deep philosophy there was.
Right. I mean, Volokh runs a clinic called the First Amendment Appellate Project for UCLA. It's essentially a third-year elective course. I know because it's basically something where he wants financial support from UCLA alumni. So I get the pitch every year from him. And basically he's a smart guy that really is focused a clinical course in appellate advocacy on First Amendment issues. And it's a very well-regarded course. They do a lot of pro bono type briefing in First Amendment cases, both in the federal and state courts. And they want to distinguish UCLA as having a certain practical aspect to the training that's delivered. And I think he's doing a good job of doing that. And he also teaches kind of the basics of getting a brief constructed and making sure the quality is good and so on. So he's a really smart guy and he's done a lot of interesting stuff. And yeah, I mean, I disagree a little bit. Kavanaugh was the one that referenced his brief, and I did send you a copy of his brief. I disagree a little bit with his view. You've heard it from me.
Which way? I mean, do you think that he was wrong about the cake is not covered, or that he was wrong that the website is covered?
No, I think that he's right about the cake not being covered, and he might be partially wrong about the website because the website is not entirely unique and expressive and First Amendment content. In that respect, I agree that the comments at the very beginning by, I think it was Kagan, it might have been Sotomayor as well, that, hey, look, this is just facts. This is like an assembly of dates, times, places, and so on. she didn't quite say it this way, but she could have. Couldn't Miss Smith just say, here, I can deliver this, but I really can't deliver the rest of this more unique
Yeah,
thing.
she could, but she doesn't want to.
Right.
Anyway, we're now going around again. But
right. Lorie Smith is saying in so many words, it's sort of against my conscience to do it, so I don't want to do it. And I have a First Amendment right not to be associated with it. And that's my business. So thank you very much. And of course, the state is turning that into much more of a status discrimination. So we've covered that and done a good job doing it. So I want to thank you for doing that and appreciate you coming on. And we'll set something up to address these other cases as they start to roll out.
Real good.
Thanks very much, Bob. Take care.
Okay. Have a good night.
Bye. You too.
Tune in next time on The Valley Current.